Дорогие друзья, мы начинаем пленарное заседание.
Dear friends, we are ready to start the plenary session of the 5th St. Petersburg International Legal Forum.
Дамы и господа,
Ladies and gentlemen, for the opening address to the participants of the 5th St. Petersburg International Legal Forum, I would like to invite on stage the chairman of the organizing committee of the forum, the Minister of Justice of the Russian Federation, Alexander Konovalov.
Перемены.
Changes. Are they for the worse or for the better? Changes require decision-making, and people, as is well known, do not take decisions. However, on the other hand, only in a changing, dynamic, multifaceted society, innovations become possible, which are absolutely necessary for further development of man and mankind and tapping their full potential. What kind of role can lawyers play in these changes? I think I won't be wrong if I say that this role can be huge. The best representatives of our profession can help the society find a justified balance between conservative and innovative approaches, to optimize technologies without losing their link with the global vision of trends in the development of society, with the basic principles of justice and rationality in relations between human beings. Ladies and gentlemen, on behalf of the organizing committee, I would like to welcome you at the 5th St. Petersburg International Legal Forum, the topic of which is, this year, the mission of law in an epoch of change. Changes mean new risks, and new risks require changes. Let us make those changes positive. I would like to wish you successful work at this forum.
Уважаемые дамы и господа,
Dear ladies and gentlemen, I would like to invite the participants of the plenary session of the 5th St. Petersburg International Legal Forum, the moderator of the plenary session, Veniamin Yakovlev, advisor to the President of the Russian Federation. Miguel de Serpa Soares, Under Secretary General of the United Nations for Legal Affairs, Wolfgang Brandstetter, Federal Minister of Justice of the Republic of Austria. John Finnis, Professor of Law and Legal Philosophy, Emeritus, Oxford University. Andrea Orlando, Minister of Justice of the Italian Republic. Renaud, Secretary of the United Nations Commission for International Trade Law. Alberto Mazzoni, President of the International Institute for Unification of Private Law. Chairman of the Government of the Russian Federation, Dmitry Medvedev.
Good afternoon, dear colleagues. Today it's the 5th International Legal Forum. We have all gathered here in a very beautiful place, which is a very nice thing and interesting thing. I would like to emphasize that over these 5 years, the forum has turned into a very famous platform. I might even say a leading platform, international platform, which is demonstrated by the number of participants to this forum. We have more and more participants every year, but it's not only about the number of participants, but also about their representation. In 2011, representatives of 35 countries came to St. Petersburg, and this year we have more than 3,000 guests from 84 countries of the world. And it means that this forum is a full-scale international representative forum and a substantive forum. Here we're discussing the very complicated issues of the development of law, and one of the topics of today's plenary meeting is mission of law in the era of change. As you know, it's not very easy to live in the era of change, but changes always take place, and the mission of law is always there. I would like to remind you the words of the famous German lawyer and thinker Rudolf von Gering. The end of the law is peace, but the means to that end is war. The period of change always involves struggle, not only for the change of social relations, but it is a struggle for the law itself. We can't measure our success only with the number of regulations that we have adopted or international treaties that have been signed. It is much more important to understand how solid and efficient the legal basis is at this very stage, because it is the foundation for the existence of our states and societies. Law, as it is known, is in its nature a very flexible and living structure, and we as lawyers are convinced that it can give an efficient response to any social changes and challenges of today's world, including through traditional regulations or through legal experiments, but without infringing upon fundamental rights and liberties of citizens. For the government of the Russian Federation, which I have the honor to represent here, law, first of all, is an important instrument for dealing with current social and economic tasks, and it is also a set of criteria which lay down the foundation for the elaboration of strategic directions of our activities. It is a compass which can help us find solutions to any tasks, starting from approaches to international cooperation and ending with state procurement rules. And given the rapidly changing norms, which just yesterday seemed unshakable, we can't do without such a compass. So we must all protect the law and keep it and preserve it. I believe that our mission, the mission of us as lawyers, is to protect the values of law, has not become irrelevant. And I've mentioned it last year, speaking at this forum. I idea is still relevant, and I hope that the St. Petersburg Forum will serve this goal. In the 21st century, legal regulation is becoming more and more complicated and fragmented and more integrated, and to maintain the legal system in its good condition, we must create new legal constructions and make decisions, including experimental decisions. We also make such decisions in our country. We adopted such laws last year. One of them allows to develop the Far East region, providing for mechanisms for rapid development regions. First, this idea was designed for the Far East region, but then we came to the conclusion that we can extend these mechanisms to other parts of our big country. And the second law establishes a special legal construction for the free trade zone in Crimea. Besides such outside-the-box solutions, law is still renovating in Russia through traditional means. Large-scale modernization of civil legislation is at its final stage. We've been preparing new norms in such a way so that each legislative innovation could be thoroughly examined, although it's not easy, and sometimes we had to coordinate and bring together very different positions of all the participants. The Russian Civil Code now includes institutes which have proven that their efficiency overseas, and they have been tested by businesses. Now, corporate law includes new institutes of public and non-public entities and a common institute of corporate agreement, which allows the sides to deal and to govern their relations in the most efficient way. And radical changes to the section on liabilities will enter into force next week, since the 1st of June. For the first time, the code includes norms on option, contract, security, payment, subordination, agreements, and also many other norms, which I hope will improve the image of Russian jurisdiction for entrepreneurs. The adjustment of civil legislation lays down new, more exact legal constructions, which must lay down the foundation for the economic development in our country and guarantee protection, due protection of rights and legal interests to foreign investors, not worse than they could get in other systems of law. I have listed just few innovations of Russian legislation, although guests of our forums are very well aware of them. But you understand how it is difficult to integrate categories which have been developing in other systems of law, in other legal families, into Russian legislation. In fact, our country has become one of the pioneers in the complex borrowing of legal institutes, including institutes of common law. When carrying out experiments in law and creating and borrowing new legal regimes and constructions, it is important to remember that the law, although it is a flexible instrument, it must not be broken by new factors. All legal pilot projects must be sooner or later combined into one single entity, must be incorporated into one system, into existing regulation. That is why the main foundations and principles of law must distinguish very clearly between the basic principles and variables, maybe temporary norms and permanent norms on which our system of law is based. Well, just to give you an example, I may give you the construction of mechanism of state procurement in our country, which is quite important due to the amount of such procurement. We've been facing quite a challenging task to build a single, well-structured, open system to launch an efficient anti-corruption mechanism in this sphere. Unfortunately, there is a lot of abuse in that sphere. To make Russian entrepreneurs sure that stable market rules are guaranteed for them. We've achieved a certain progress in this field. We have a new law on contract system. We have expanded our set of instruments for various tenders. And it's been 2 years since we started to implement this law. The norms are going through efficiency tasks, and to take into account the enforcement practice, we had to amend the law and to introduce several packages of amendments into it. Now, some more amendments will also be considered into this law. I'm talking about this because this issue will also be discussed at the forum. But anyway, general conditions that have become a basis of this system, they must be preserved, like development of competition, transparent tenders, publicity, professionalism of clients. All these things must be preserved. Another important segment which lawyers are now dealing with, well, not only lawyers actually, politicians are also dealing with this, and it is very closely interlaced with common people. I'm talking about the tasks that development of the internet sets forth to the legal world. When we're talking about a virtual space, imaginative, outside-the-box solutions are required from lawyers. First of all, because digital technologies and the internet are changing at such a rapid pace that legal strategies can't keep pace with them. Secondly, regulation in this sphere is very complicated. It must provide, on the one hand, for freedom of information exchange, and on the other hand, for security, protection of creativity and creative rights and intellectual rights of authors themselves, and the opportunity to use the results of this creative work. And thirdly, an efficient legal strategy in this field is impossible without full-scale international cooperation. We are all, including myself, appreciate the opportunities that Internet has given to us. But at the same time, the government of any country, including the government of the Russian Federation, must take into account the need to provide a stable and secure communication. Moreover, infringements in this field are very often of transborder nature to quite clear reasons. Given the huge amount of information that is being stored in the virtual space, it is obvious that the number of offenses in this sphere will continue to grow. That is why we must be dealing with the establishment of a good and solid basis for regulation of various consequences of these offenses in the Internet. In recent years, almost all states, including Russia, have been developing and adopting new laws in this field. Internet is a very important phenomenon, and it can't be neglected. And without legal constructions, modern legal constructions, we can't do, including in order to use experimental legal models. The ideas on the scope of freedom in the Internet are different. There are some suggestions to develop a convention on the personal data protection at the level of the United Nations organization, which could reflect the best practices of these states. But right now, frankly speaking, politicians are not very eager to discuss these issues at the international level. Several years ago, I offered to my colleagues to discuss these issues at various summits and fora, but unfortunately I don't see any progress in this field. But nevertheless, the means to protect personal data and on internet regulation must be reasonable and efficient. I know that a separate discussion is scheduled within the forum, and in the smart society, as we call it now, we must live without breaching the law. An important guarantee for the development of law, whether it has to do with internet or any other sphere of our life, are judicial decisions. Right now, there is no universal law or treaty in the international law that would distinguish and delimitate jurisdictions of courts of various states. Norms do not always coincide, thus causing a great number of difficulties. Besides, states are seeking to broaden the jurisdiction of their courts. And sooner or later, each legislative system must precise how exactly foreign judicial decisions will be implemented on its territory. It is a very complicated issue for lawyers, and avoiding the so-called interference into sovereignty in the era of internet and transnational economy and global trends, it is almost impossible. Although every country decides on its own how widely it is going to open its doors to decisions adopted by other states. In Russia, we believe our decisions depend on whether there is an international treaty with the country whose court has announced the decision. We have a lot of such treaties, and they touch upon a wide number of civil cases. We also recognize voluntary settlements and criminal sentences on compensations are also recognized. Decisions of foreign arbitration courts are also to be executed. But there are some problems in this field and some opportunities as well. But this situation, everyone has been satisfied with the situation until this very moment, but specialists say that the Civil Procedure Code of Russian Federation should be amended, should be improved, because there is a serious danger of politicization of judicial decisions. And other states are talking about it, and we are talking about it as well. Many of these issues will be discussed within the forum today, starting from the development of international arbitration to protection of business in case of bankruptcy procedures. I hope that colleagues will be able to offer some new outside-the-box ideas which will help to relieve existing problems in this field of law. This is extremely relevant for today.
Dear colleagues, the existing system of international law is only efficient when it is implemented through internal law. Yet it is evident that we cannot utilize those mechanisms to disguise our current policy goals, our long-term interests. It is in our long-term interest to have a set of progressive and democratic binding norms. So, in international level, it is necessary to preserve legal tools of peaceful settlement of arguments and develop mechanisms of making and interpreting coordinated decisions. Such mechanisms are provided for within UN, within World Trade Organization, Council of Europe, other international entities, and now we have it within Eurasian Economic Community. The treaty of its creation was signed a year ago between Russia, Belarus and Kazakhstan after 2 years of negotiations. It's a new stage of Eurasian integration. The norms that are implemented within the Eurasian alliance take into account rules and principles of the WTO, and the legal basis of Russia's economic policy will be tied with implementing norms and principles of WTO and EEC at internal level, including, together with our partners, we'll have to harmonize energy laws with regulations of EEC. Russia, as well as other members of the community, are open to cooperation. We profit from the status of full membership of WTO. It is necessary for economic development of the country and promotion of our goods in external markets. We have to admit that no country in our time can be self-sufficient in all goods and services, and so the international community is destined to integration. Today, the EEC was joined by Kyrgyzstan and Armenia. We have prepared a new treaty, free trade agreement with Vietnam. That is the first treaty of this kind for the EEC. The day after tomorrow, we are signing it at the meeting of the heads of governance in Kazakhstan. This interest shows that our economic community has good prospects. We plan to develop interaction with our Chinese partners, communicating the Eurasian economic integration and economic belt of the Silk Road. That is a positive experience. It makes us re-evaluate the way our relations develop with the countries of European Union, United States and other countries. The last year enriched the international legal field with life and so-called sanctions life. It doesn't mean that it is an unprecedented event. In a certain way, we all come back to the 20th century. I have reiterated that for the last 100 years, our country was systematically lived under sanctions. But right now, our legal system is very different from what it used to be. A lot of approaches that we didn't use earlier are now reflected in our set of laws. Today, our law system is part of international law system, and any illegal method of coercion has inevitable effect on the law as a whole. I'm not going to have lengthy discussions on the current events. I'll just remind you that last March there has been a referendum in Crimea when most citizens voted for reunifications with Russia. Our country recognized its results. Then certain states introduced sanctions, unilateral sanctions. That's not collective coercion if we're talking about actions because there were no sanctions imposed by the United Nations Security Council. There was later the deteriorating situation in the east of Ukraine brought about harsher unilateral sanctions, and they were aimed against certain industries of our economy and certain citizens and certain companies of our country. We, and I'm not very happy to tell you about it, introduced limitations concerning important agricultural products, raw materials and food in our territory, and all the parties to the conflict are members of the World Trade Organization that was created to lift any obstacles from the path of developing trade. Moreover, the rules of WTO were used to justify unilateral sanctions. First, our colleagues and partners referred to limitations in the regulations of the organization. Then, in this case, Russia using exemptive clauses that are provided for in the regulations of the WTO, made a decision to protect its food market. That's the set of events that took place. I do not believe that's a good development of world trade relations, but I have to say that in the near future we'll have to make decisions either to extend those measures or to lift them. But our actions will be adequate, and they will be based on the actions of our partners from other countries. But despite the events of the last year, I believe that we are not talking about crisis of international law. We are talking about crisis of states' attitude to international law. What would be our response to those events? For me, it's evident we have to go back to single understanding of international law. First of all, the provisions of the Charter of the United Nations and international conventions that protect the human rights in all spectra of existing problems in the world. That would help us restore trust in recognized principles of law on the international levels. It depends on our, dear colleagues, on our professional solidarity, because its legal community understands that there is no alternative to universal instruments of law. And these instruments we have. Dear colleagues, ladies and gentlemen, dear friends, before concluding, I would like to remind you of one date that I believe you know about it. Today, the 27th of May, is the anniversary of the foundation of St. Petersburg. On the 27th of May, 1703, Tsar Peter I started building the city that became the symbol of reforms in Russia, that to a certain extent opened Russia to communication with the Western countries and effectively created a stable basis for political, economical and cultural cooperation, leading our country in the embrace of continental legal tradition. A century later, one of our brilliant jurists, Mikhail Speransky, systematized our legal experience, creating the first code of laws of the Russian Empire, further developing our legal system. Today, our legal framework is still changing. As I have already said, we have assimilated the elements of other legal systems. In the recent 20 years, we have included in Russian legal framework a great number of internationally important norms. It's a living, dynamic field of law, leaves enough space for advocates of its active interpretation and those who defend its basis. And in legal framework, there are both types of specialists. I believe that for the participants of this 5th International Legal Forum, there is no more important mission than serving the law. I believe that you have 2 days that you could spend on this beautiful aim. I hope that you will have very productive work in different fields, and I wish you not only interesting discussions. I also hope that you will have the opportunity to walk the streets of St. Petersburg. The weather is just fine for this kind of activities, and this could help you understand how much we share. Thank you for your attention.
Надо нажать, Вениамин Федорович. Уважаемый.
Dear Mr. Medvedev, thank you very much. Dear ladies and gentlemen, dear colleagues, before we proceed to the discussion of the main topic of our forum, the mission of law in the era of changes, taking into account those comments that Mr. Medvedev has just made, I would like to say that a very important aspect of international relations is international trade. Outstanding successes in the harmonization of law in the field of international trade, and the role here is played by the Commission of the United Nations for International Trade Law, UNCITRAL, within the framework of which we not only work out international treaties, but also work out legal instruments of recommendational nature, soft law, model laws. This year we are celebrating the 35th anniversary of the International Vienna Convention on International Trade of Sale of Goods, which remains the pivotal international instrument in this field. And it is my pleasure to give the floor to Mr. Renaud Sorieul, Secretary of UNCITRAL. Mr. Sorieul, you have the floor.
Thank you, Moderator, for your kind words about the work of UNCITRAL. Excellencies, distinguished colleagues, ladies and gentlemen, I would first like to thank the organizers for associating the United Nations Commission on International Trade Law, UNCITRAL, to this important event. I am privileged to serve as the Secretary of UNCITRAL And I can say that the theme of this forum, Mission of Law in an Era of Change, exemplifies the core consideration that UNCITRAL member states and the member states of the United Nations at large consider as they develop the trade law standards for which UNCITRAL is known. In formulating that consideration, the question our member states ask is, what is the mission of law in an era of increasing and rapid change in the commercial law landscape? As an extension of this question, I would like to discuss three ongoing and related changes in the commercial law rulemaking context and UNCITRAL's approach to these transitions. The first change is a move from seeking unification of the law of commerce to promoting its modernization and harmonization. The second can be characterized as a shift from a focus on development of trade law purely at the international level to a recognition of the importance of the domestic and the regional perspective. Finally, I would like to address a third trend towards increasing awareness of the importance of commercial law and commercial law reform to sustainable development and the development of the rule of law. To understand the first transition from unification to modernization, it might help to have a little background on UNCITRAL, which was established in 1966 to develop global standards in the area of international trade law, at the time with a focus on East-West relationship. UNCITRAL does not deal with trade policy, which is the domain of the World Trade Organization. It rather specializes in improving the legal framework that governs the commercial transactions of business partners and traders at the microeconomic level. UNCITRAL's process in developing this framework is characterized by transparency and inclusiveness. UNCITRAL's member states represent every region of the world and every stage of economic development and, of course, every legal tradition. All United Nations member states may participate as members or observers, and due to UNCITRAL's consensus decision-making process, they have an equal opportunity to inform decisions. Other international organizations are also included and of great importance, so are the end users of UNCITRAL's texts, the lawyers and commercial operators. This mix of public and private stakeholders and interests gives UNCITRAL's work particular legitimacy. In view of both state needs and those of private actors, legal standards prepared by UNCITRAL represent what the international community considers at any given time to be the best international practice in a specialized field. In addition, all this work is conducted in the public view. Recordings and reports of all UNCITRAL's meetings, as well as the documentation it considers, are readily available online in the 6 languages of the United Nations. I would like to address UNCITRAL's transition from aiming at the unification of commercial law to facilitating its modernization and harmonization. Traditionally, UNCITRAL's work has focused on the differences between countries in their domestic legislation governing trade. This focus was inspired by the observation that these differences can and do operate as barriers to commerce by creating legal uncertainty, which in turn generates transaction costs, and, for example, increases legal costs because of the need to research the foreign law applicable to a contract. These costs can result in a significant hindrance to trade. To address the differences in domestic legislation, UNCITRAL's traditional approach is to attempt to unify the law in that area, as was the case with the United Nations Convention on Contracts for the International Sale of Goods. In that case, unification by way of a hard law convention was an extremely effective approach. The convention's 83 state parties indeed account for more than 80% of the global trade in goods. That approach, based on hard law and conventions, remains valid. However, there is a growing recognition by states in UNCITRAL that while specific legal differences in certain areas may create barriers to trade, the primary barrier may be the result of more systemic issues at the national level. The extensive trade between certain common and civil law countries with very different legal systems is a testament to this observation. Rather than disparate legal traditions, it appears that the biggest obstacle to trade in some countries is the unavailability of a domestic legal regime that can account for the quickly changing conditions in commercial law. For example, a legal regime that does not effectively enable electronic contracting or the type of continuing contractual relationships that are characteristic of the modern global supply chain may deter trade both domestically and internationally. For this reason, much of UNCITRAL's work is designed to potentially apply as much to purely domestic transactions as to international ones. We can see this trend in UNCITRAL's work relating to alternative dispute settlement, electronic commerce, insolvency, online dispute resolution, security interests, public procurement, and finally, and more recently, to the creation of an enabling environment for micro, small, and medium-sized enterprises. As part of UNCITRAL's focus on shifting from unification to providing governments with the tools they need to modernize and harmonize their laws, rather than conventions, which are still useful in some circumstances, you will see UNCITRAL more and more producing model laws, legislative guides, and other soft law instruments that give states, if they choose to adopt them, the flexibility to adapt those instruments as necessary to their domestic legislation. The shift in UNCITRAL's attention away from purely international also touches the second transition I would like to touch on, the increased significance of the regional perspective in commercial law legal standard setting. Over time, there has been a proliferation of regionally focused entities, both intergovernmental and non-governmental, engaged in formulating rules of international trade designed to harmonize the legal environment at the regional level. One of the most visible is perhaps the European Union, but of course there are many others on every continent, and I'm particularly pleased here to mention the efforts underway in the context of the Eurasian Economic Community. From the perspective of UNCITRAL, this proliferation of regional initiatives has come with many benefits. For example, the development at the regional level of expertise in some of the fields in which UNCITRAL's work, in which UNCITRAL works, and where there have also been challenges. The first among challenges is that despite UNCITRAL's mandate to coordinate the work of organizations active in international trade law, there is no binding mechanism to assure the cooperation of all these organizations. Thus, internationally and regionally focused organizations may frequently address the same subject in their law reform efforts. This may result in an inefficient use of resources, and the solutions finally adopted may be in conflict with one another. UNCITRAL has found itself appealing to regional bodies, and here I have mostly the United Nations Regional Economic Commissions in mind, to address these inconsistencies, which can lead to uncertainty for commercial operators and have thus the exact opposite effect to what was intended. Beyond this particular challenge, issues can also arise if the economic stature of a regional organization and its traders leads to its norms being imposed beyond its boundaries. In those cases, such norms don't necessarily represent the best global solution, and their imposition may be problematic for states that were not involved in their creation. In many instances, I do not forget that regional organizations are the best situated to understand regional and local needs and to provide the optimal solutions for that context. However, the concentration of efforts to reach regional integration is such that lawmakers in a given region may easily lose sight of the broader perspective of trade law beyond the outer limits of the regional organization. UNCITRAL is there also to remind everyone of that perspective. In an attempt to balance the benefits of regional initiatives with the needs to assure their compatibility with international efforts, UNCITRAL is experimenting with a more regionally focused approach, in particular when it comes to implementing UNCITRAL standards. The UNCITRAL Secretariat has long prioritized technical assistance to law reform at the regional and sub-regional level, which can be an efficient way to target audiences with shared needs, legal traditions, and languages. To supplement these efforts, UNCITRAL is now testing the effectiveness of having a dedicated regional presence. In 2012, thanks to a generous contribution from the Republic of Korea, we established a regional center for Asia and the Pacific, a center which is now able to more directly facilitate commercial law reform in a region notable for high interest among states in harmonizing commercial laws. In addition, the center has the capacity to cooperate more directly with other organizations promoting trade law in the region. Additional efforts for creating comparable regional centers are being pursued in other regions, including in Africa and in this region with CIS and Eurasian countries. The pursuit of trade law reform brings me to the final trend I would like to discuss, which is the growing recognition by states over the last several years of the importance of commercial law to sustainable development and the development of the rule of law. These are key considerations as governments design the post-2015 development agenda of the United Nations. It is often observed that rule of law is an important component in sustaining economic development, investment, and entrepreneurship. Until recently, however, the role of commercial law in that development was often neglected, with the rule of law and sustainable development discussions focusing primarily on public law, human rights, criminal law. While those considerations are important, states are now understanding that a sound regulatory framework for business, investment, and trade is also essential for sustainable development. I might add that modernization in that field is also a fairly inexpensive way of reaching sustainable development. Consider the case of post-conflict societies. Criminal justice and electoral reform may be essential in the short term, but the long-term prosperity and peace will be based in part on the existence of a viable and vibrant economy that encourages entrepreneurship and investment. A sound regulatory framework that can support such an economy, such as access to justice, consists not only of rule of law fundamentals such as access to justice, but is also about the recognition and enforcement of property rights and contracts, the security and availability of credit, and the recognition and formalization of business entities. These are some of the important areas in which UNCITRAL has worked and is currently working. UNCITRAL's work also touches the public sector. Its model law on public procurement is a key standard in combating corruption in government purchasing. At the national level, outdated law in any of these areas will stifle entrepreneurship at home and discourage investment from abroad. And it is UNCITRAL's goal to provide the internationally accepted standards that can modernize and harmonize these laws. Unfortunately, even as the importance of commercial law to sustainable development and the rule of law has become more visible, it is equally apparent that the capacity at the local level to implement commercial law reform can sometimes be limited. Commercial law is constantly evolving, and its reformation demands expertise at the national level in both lawmakers and advisors. In UNCITRAL's experience, it is often difficult to identify government officials with commercial law expertise. In general, because of other priorities, local needs in this area are often not addressed. I'm discussing here, of course, mainly the problems encountered in developing countries. Beyond that, both domestic and international financial resources for law reform are frequently directed to other areas of law. Finally, in some states, modern commercial law exists, but because of a lack of capacity in the judiciary and the legal community, they are poorly applied or even overlooked. While the general trend is towards a recognition of the importance of modern trade law standards, the lack of domestic capacity to engage in meaningful commercial law reform is absolutely one of the main challenges UNCITRAL faces going forward. In fact, it is an underlying challenge related to all three of the transition or changes that I have discussed today. States now see the need to modernize trade laws, to maximize the benefits of regional cooperation activities, and to reform commercial law in order to foster sustainable development. This is their mission in an era of change. To succeed in this mission, however,
именно это и является их миссией во времена перемен. Для того, чтобы эта миссия стала успешной, совершенно необходимо мобилизовать местные, локальные знания и также возможность помогать технически для того, чтобы обеспечить реформу торгового права. UNCITRAL в особенности
contribution of commercial law to sustainable development and the rule of law. Thank you for your attention.
Спасибо, господин Sorieul.
Thank you very much, Mr. Sorieul. And now among the speakers at this plenary session, we have the Minister of Justice of the Italian Republic. The relationship between Russia and Italy have a long-standing history. The Republic of Italy is one of the most important partners of the Russian Federation in Europe, with which we're developing an intensive cooperation, and we're having a very busy dialogue. The Italian legal science, in fact, is a keeper of the traditions of millennia of the Roman law. The system that historically is the foundation for the law and the legal system of the modern state. And the overall construction of the legal system of Italy makes it possible for us lawyers to understand one another better at every time and in every era. Thank you. Mr. Orlando, the floor is yours.
Rivolgo innanzitutto il mio saluto e ringraziamento al primo ministro della Federazione.
Well, in the first place, I would like to thank the Prime Minister of the Russian Federation, who has gathered us here in this outstanding city that, in fact, today is celebrating its anniversary. Thank you very much for gathering us here at this forum that has become lately one of the most important tools for a dialogue and for the exchange of experience and opinions between the representatives of different legal traditions and standards. I would also like to cordially welcome the Minister of Justice, Minister Konovalov, and all the other speakers and participants of this forum. I believe such fora that make it possible for us to exchange opinions are in fact very important venues for all of us to work out a common language that will make it possible to capture, to analyze, as well as to understand the global changes that are currently underway in the world. Usually, when we are talking globalization, we focus our attention in the first place on the phenomena that mainly over the past 30 years especially have led to dramatic transformations in the world of economy and finance. For instance, we're talking a lot about the positive and negative impact of such processes in terms of the current economic situation, in terms of the state of affairs related to the daily life in specific countries, regarding the opportunities they open up and the risks and challenges related to them alike. At the same time, we far less tend to think over the following. It is the law, specifically the law, that's made it possible for these processes to range to the scale that previously would have been unimaginable. I'm not referring to the traditional law developed by the state or the classic public law. I'm hereby referring to the new global law that is a consequence of the impact of multiple centers for decision-making, for multiple centers for the regulations, within the framework of which way too often individual countries turn out to be too passive and they can only consider the changes in their national legislations. I'm here referring to the new regulating processes of the global nature that today is developing regardless of the states. Globalization, the global financial challenge and crisis have posed a whole number of significant challenges to us. The focus is currently on the regulating crisis as one of the causes for the financial crisis. The financial crunch and the crisis of the institutions that turned out to be incapable of managing the globalization process, the crisis of democracy following a certain disregard of democracy, which we see stemming from the centers of regulating the olden concepts of the state, the regulating, the policy and the politics are superimposed by a new concept, the global governance. That is, they emerged the new centers for decision-making, the level of the developments of the contractual law in economics and finance lead up to the emergence of the self-regulating systems, the institutions, as well as the financial agencies, the industry-specific associations ranging from banks to insurance companies and to internet companies, the supervision and control authorities, the international courts, the international arbitration system, the expert communities, the international global trade, human rights, labor-related issues, security and environmental protection-related issues, the matters of finance. All of this altogether imposes the will to specific states and individual citizens. And against this setup, I believe it is actually very iconic what happened during the Italian presidency of the European Union. Throughout the Italian semester or session, one of the major issues mentioned here by the Russian Prime Minister, among others, was the issue of personal data protection. And at the same time, they had to deal with the decision-making involving the public institutions, legitimate and democratically elected in their turn. At the same time, another process was ongoing. There was a whole global campaign on the way that was establishing its own system of law, dedicated specifically to implementing it. I'm referring to the Google company. This is also relevant to the economy. The economy today has trespassed the national borders, and therefore the law was developing in exactly the same direction. And in many ways, it anticipated the changes forthcoming in the economy. And that's exactly why it's so important to see how law is related to the economy. This excited the inception of the reforms in our country that call on a number of measures to be taken on the legal level, in the first place in civil law, in order to make sure the laws are implemented in due time and course for all the agents of the economy. In fact, law has to be far more sensitive in capturing all these changes. The power that traditionally has limited itself to the national borders has trespassed these borders now. And oftentimes, this process is not coordinated. Nevertheless, we do find ourselves under the impact of this process on whole sectors and industries of our lives. Today, the law on the national level is being adapted to the international norms and standards. Oftentimes, they speak about these sanctions that have a reputational nature to them. And all of this leads to the fact that we are compelled to answer multiple questions. Now, what is the foundation of this power? How legitimate is it? Who manages these processes? Who plays a major role in these changes, and what is the role of the law in these changes? St. Augustine said, what would the realms or states be without the law, if not just a bunch of thieves? Let us think about it, and in fact it's the multiplicity of the centers of regional control do not report and are not subordinate to the law. In the olden world, this usually had to do with limiting the power, the authority. The focus of this theme was that of the sovereign power or authority that could grant certain rights to the players, to the people, however, within certain limitations. Now, the process of the development of a constitution was based on the fundamental norms and standards. Part of this positive law was moved out of the sovereign power, and the power itself was under the restrictions imposed on it by the law. This was, in a nutshell, the process of the development of the rule of law. In fact, the rule of law served to be a warranty, a guarantee to protect an individual citizen before the power and the authorities, based on the need to use the tools and instruments which the government supplied to instill the authority. At the same time, it had to do a tool that would rule out a number of opportunities for the authorities that guaranteed the protection for the citizens against the abuse of power. Between the 15th and the 16th century, we witnessed the aggregation, the concentration of power. Take Europe. In the past, prior to the modern times, there were about 1,000 centers of authority, centers of power. In the early 20th century, their number was reduced to about 30, just in accordance with the number of states in this continent. On the brink of the 20th and the 21st century, this process seems to have reversed the classic constructs of the power, the authority, this state that in 1945 included about 50 states. Today, this number has grown to about 200 of them. Apart from the states, we see the emergence of a lot of international subjects, players, international organizations, transnational companies that through their activities are now making dubious the role of the states themselves. In Europe, this meant undermining the two foundation features that ensure the legitimacy of the development of the state, that is the social state and the state of law, the legal state. Both concepts, in fact, found themselves under pressure. To what extent is the state still the key player, the major link in the chain of the contemporary global legal system? How do the systems of industry-specific regulation function today? In the national legislation, there is a set of certain rules and regulations that are then subdivided depending on the industry. Nevertheless, at the same time, there is a coherence and consistency within the system. The activities of a human being are now regulated essentially by the global norms and standards, and these are much different from one another. At times we talk about just about the framework norms and principles and standards, whereas in other cases some criteria can even be imposed directly. At the same time, it may be the case that we have some global bodies playing the role of judges. In fact, at times we talk about the tools of legal settlement to the conflict. In other cases, such tools are not available, so it all progresses through the negotiations or at the level of national jurisdictions. However, if we do not have a cumulative set of rules and regulations that would unite all of us, how will we be able to live on and through? How will this process develop further on? Over the past several years, we have seen the emergence of a number of centers of power, of authority that do not have any legitimacy, that cause tension in the lives of states.
And prevent sovereignty and control by the population of the actions of the government. Very often now, many people believe that within the framework of national legislation, the problems and issues cannot be resolved, and the intentions and aspirations cannot be met. Also, widespread is the concept whereby national legislation, global legislation can no longer permit development, and we need to somehow close within our smaller countries and smaller legislations. Indeed, national legislations would sometimes prevent us to have a proper look at global phenomena. But there's another issue, and this is a very timely issue, given the fact that in many countries we see some centrifugal developments and some nationalist movements are on the rise. The European Union has been an attempt to create a global management tool, to create a single political, economic and ideological space that would be legitimate, but at the same time it would be able to protect the public from the negative consequences of this process, especially from the tensions about the links between economics and democracy. However, the future goal was to integrate all members within the single European space. That was probably a utopia, but this was pronounced by the countries after the end of the two world wars. We know about the precious contribution of the Soviet people into the victory. But coming back to the subject matter of our discussion, I'd like to say that in the very beginning of the European integration process, law has played a fundamental role. First, it was an instrumental role, but in parallel, we also saw a process which provided law with some autonomous functions. And thanks to that, the European integration was an integration based on law, primarily. In the late 60s, the European Court came up with a whole code of principles and rules which were the basis for European law. The fundamental rights were extended within the framework of the Council of Europe with the adoption of the Human Rights Convention. And when European institutions have been established, like the European Association for Coal and others. And finally, we came to the Treaty of Maastricht. And basically, they culminated in one point. Schuman mentioned that Europe cannot be created overnight, and we cannot do so even together. And this is the consequence of individual processes, which would be the expression of solidarity, of individual solidarity. The identity of Europe is that it is the most advanced political space in the area of fundamental human rights and protection of human rights. Some people still think and want to have Europe go each other way into their national legislation. But these are the consequences of the failures of the past. And one of such failures was the attempt to create a common European space, not only based on common economic and financial goals, but also based on democracy, which would place man in the focus and This is a way with many obstacles on it, and there would be the danger of some marginal processes in individual countries, and it would also mean harm to the whole of Europe. However, Europe should be a guarantee to other partners, because it is only in this way that we can meet the numerous challenges and threats of today. Some of these dangers require maximum cooperation between states and common strategy. Suffices to remember the threat of terrorism, which is a threat to our communities, to the rights and freedoms of our citizens. Our strategy should also aim at a global fight, because the transnational character of this phenomenon requires exchange of opinions and information. We need to develop cooperation between law enforcement agencies, between the intelligence agencies, and we also need to think about the human rights and freedoms. And terrorism is not the only threat which endangers our future. The experience of Italy demonstrates that there are no less important dangers to freedom and liberties and economics, and in the form of organized crime and mafias. The recognition of the fact that there is a stronger, growing link between the international criminal organizations stimulated such international organizations and institutions like the UN and the European Union to launch a slow, for now, process to combat mafia-style crime. I think we need to adopt new decisions, because mafia today is one of the most serious dangers to our citizens, to the liberties of our citizens. And in conclusion, I'd like to really remember the topic of our forum today and think about the creation of a multi-tier system where the role of a national state would be relying on a large network of institutions created by public and private linkages. And this is a very important level, the second level of power. This affects the lives of citizens and communities, but we here need to think about legitimacy, and thinking in an era of changes means that we also need to create a global context, a new global law, if you like, and this means that as far as Italy is concerned, we also need to bring our national legislation in line with the dynamically changing international realities by preserving at the same time the traditions of the Italian law. And I think that here the Russian Federation can also play a very important role. The Council of Europe is an important international institution to promote the processes that we have touched upon. I think that this is an ambitious plan, but this should also serve as our goal. We need to create such a construct so that the processes of globalization can provide in full its positive effect instead of endangering our values and liberties. Thank you. Thank you, Mr. Orlando. One of the guests of honor here would be Alberto, who is the director of the International Institute for the Unification of Private Law, which was established in 1926 as an auxiliary institution of the League of Nations. But UNIDRA today is an independent international non-governmental organization which plays in the world a leading role in promoting modernization and unification of the private law of different countries. Mr. Mazzoni, please, the floor is yours.
Honorable Prime Minister of the Russian Federation, Honorable Ministers of Justice of the Republic of Austria and of Italy, distinguished speakers and guests, ladies and gentlemen, it is a great honor to to participate in this high-level panel under the highest auspices of the Prime Minister of the Russian Federation. UNITRAL is proud to count this great country among its most active and supportive member states. Russian legal experts have contributed to our work in many areas, and your continued participation in our work has not only ensured a desirable level of diversity in the legal, social, and cultural influences that our work has benefited from, but has also often been crucial to guarantee the high quality of our products. I am therefore deeply grateful to the organizers for giving me the honor to participate in this panel today. I address you as President of the Governing Council of the International Institute for the Unification of Private Law, UNITRAL. UNITRAL is an independent intergovernmental organization with its seat in Rome. It was created in 1926, as the moderator mentioned, and mandated to prepare drafts of laws and conventions with the purpose of establishing internationally uniform laws and facilitating international relations in the field of private law. Our 63 member states are drawn from the 5 continents and represent a variety of different legal, economic, and political systems, as well as different cultural backgrounds. The independent status of UNITRAL amongst intergovernmental organizations has enabled it to pursue working methods that have made it a particularly suitable forum for tackling more technical and correspondingly less political issues. In its nearly 90-year history, UNITRAL has worked on over 70 projects, some of which have later been adopted as international conventions by other organizations, and others that have been finalized by UNITRAL itself. UNITRAL has used a flexible approach in its working methods, adapting both the process and the form of the instrument to the needs of the sector or industry concerned and the legal and political requirements of the project. UNITRAL typically holds extensive consultations with scholars and practitioners from countries with different legal systems, and the actual work that leads to the adoption of an international standard involves experts and government representatives from a large number of countries, thus ensuring that the final product may be acceptable to a majority of countries in the 5 continents. It is from the standpoint of this experience that I would like to share with you a few thoughts on the mission of law in an era of change. The years that followed the end of the Cold War, some 30 years ago, unleashed a chain of profound transformations in the world that can still be felt today. The enthusiasm about what was then hoped to be the beginning of a lasting era of peace, prosperity, and democracy led some to go as far as to declare that our society had reached the end of its political evolution. The more sober historians who survived the many human and economic catastrophes that have marked our first years in paradise are bound to acknowledge, with relief or resignation, that history has not ended, that we have not yet witnessed a radical change of the nature of man, and that states, boundaries, and governments, despite their notorious imperfections, still exist. Yet, not all remains the same. If state sovereignty as such has not disappeared, and is not likely to do so in the near future, there is growing consensus about the collective responsibility of all states to foster the development of international normative standards and to implement them by adhesion or compliance. However, the need to develop international normative standards coexists with a greater awareness of the complexities of the issues to be tackled and the weaknesses of any attempt to build an effective rules-based system without, at the same time, seeking a parallel improvement of the social and economic conditions in all nations, and in particular in the less developed nations. The lesson that we have learned is that, to this end, the law has a crucial role to play in two strictly linked perspectives. On the one hand, international trade, finance, and investments are certainly needed to encourage progress towards an enhanced global prosperity and a more equitable distribution of the latter. But the availability of none of these important tools may be taken for granted. They all require an adequate level of legal certainty and predictability. New technologies, integrated logistics, evolving commercial practices, fast-growing financial markets, complex supply chains are but a few examples of situations calling for a modern, business-friendly legal framework. Where transactions, by their very nature, tend to be transnational, the legal framework, too, should consist of uniform, widely accepted solutions. On the other hand, experience, as well as ethical and political judgments, converge in telling us that the improvement of business context is not per se an adequate or satisfactory result. Significant progress must also be achieved in the fight through the law against poverty, poor life quality, environmental depletion, illegal migration, organized crime, and other sources of social instability and lack of substantive justice. Thus, two are the goals that through the law the international community must pursue in parallel. On the one hand, facilitating trade and economic interconnections, and on the other hand, promoting sustainable development, having regard in particular to a fair balance between economic efficiency and social justice. Both goals are essential to the construction and maintenance of peace. It is self-evident that peace is threatened by poverty, social injustice, and unbearable inequalities in economic development. However, peace is also threatened or hindered if its economic foundations are disregarded, and if the role of trade and economic cooperation in preventing international conflicts is forgotten or misunderstood. It is well known that free trade of goods and services is a powerful factor in building a favorable environment for peace. It is perhaps less known, but equally true, that free access to capital also plays a similar and very relevant role. In other words, not only cross-border free circulation of goods, but also capital interdependence contributes to peace. In pursuing these peace-fostering goals, there is not only a major role to be played by the cooperation between and among states under rules of public international law. In parallel, a very significant and sometimes fundamental role may, and it is respectfully submitted must, also be played by private law. In particular, by such evolutions of private law as may be inspired or guided by international legal standards developed by both private and intergovernmental organizations with a global reach. UNCITRAL is one of the three intergovernmental organizations acting at a global level and whose mission is to contribute to the global strengthening of the rule of law through harmonization of private law. The other organizations are UNCITRAL, that is the United Nations Commission on International Trade Law, and the Hague Conference on Private International Law, the Hague Conference. UNCITRAL is the largest of the three, and I will not say anything more because Mr. Sorieul, its Secretary General, has already spoken on it. And the Hague Conference is the eldest of the three sisters, and like UNIDROIT, has been active in the field of international harmonization of private law long before the UN was established in 1945. On the Hague Conference, I will only say in passing that unlike UNCITRAL and UNIDROIT, whose mission is to harmonize at the level of substantive private law, the mission of the Hague Conference is rather to harmonize private international law. In other words, to harmonize that special part of private law that deals with the rules of conflict to be used for the purpose of identifying which substantive law must be applied in international cases in which private parties are involved. It is unquestionable that the programmatic linkage of UNCITRAL to the broader goals set up by the UN General Assembly, as well as its nearly universal membership, place UNCITRAL in a unique position for being the lead international agency in the field of international harmonization of private law. However, all three sister agencies are complementary, and they are all perfectly aware of the need to avoid duplications in areas in which one of them is already working or has already accumulated valuable experience. By loyally sharing their tasks through communication and cooperation, the Hague Conference and UNIDROIT have also done and continue to do very important harmonizing work in their respective fields. And I think it's fair to say that they too, like UNCITRAL, have generally pursued the objective of legal harmonization, always bearing in mind the importance of joining business promotion and social inclusion. Consistently with this long-standing philosophy, allow me now to spend a few more words specifically on UNIDROIT's vision of its future role in contributing to the evolution of private law in the international perspective. Being aware of the constraints of time, I will confine myself to conveying three messages, which I hope will offer a clear and easy-to-remember summary description of UNIDROIT's fundamental choices. First, UNIDROIT intends to pursue not only projects promoting instruments of hard law, but also, and in certain areas even preferably, projects promoting instruments of soft law. Second, UNIDROIT intends to pursue not only projects promoting uniformity or harmonization in international trade or financial transactions and markets, but also projects promoting international harmonization in the private law regulation of agriculture. Third, UNIDROIT intends to pursue not only harmonization projects reflecting the common core of the law as is, in most legal systems, but preferably projects promoting better rules, that is, projects designed to achieve a step forward or an upgrade with respect to the existing status of the law. A philosophy of improving, as opposed to a philosophy of merely mediating or averaging. Why soft law projects and not only hard law projects? Because the essential social function of the law is to induce or promote factual observance of desirable behaviors, which function may well be fulfilled satisfactorily, even if it is not always possible or even desirable, to put in place a stringent system of effective sanctions against non-observance. In an international context dominated by the presence of states that are still very jealous of their sovereignty, a soft law instruments may not only be the sole politically acceptable solution, but also the most effective in obtaining the result of inducing widespread observance. This is all the more so in the contemporary world, where globalization multiplies interconnections among states with sometimes very distant cultures and interests and with strong differentials in development. In other words, the more active the participation of strongly differentiated members of the international community and the greater the drive towards a polycentric distribution of political and economic power, the more the sensible way to achieve uniformity or harmonization of private law in internationally relevant sectors is to recommend observance and implementation of universally accepted non-binding principles articulated in a text of soft law. This is what UNIDROIT has sought to achieve by launching, broadening, and refining the UNIDROIT principles of international commercial contracts, an instrument that is particularly well known in Russia, highly appreciated, and frequently applied, notwithstanding its non-binding nature. This is also what UNIDROIT intends to do in the newly entered field of projects of private law harmonization in agriculture. Promoting good contractual practices and merely highlighting the areas where local law should intervene by imposing mandatory rules is probably the most realistic approach, and the most beneficial solution for all stakeholders, as opposed to dreaming the impossible dream or nightmare of superimposing an international binding instrument on the national regulations of agriculture, which are intrinsically affected by localism for political reasons and out of respect for deeply rooted rural traditions. Turning now to my second message, why projects of harmonization not only in the areas of international trade and or finance, but also in the field of the legal aspects of agriculture? I believe that at this point the answer may be easily extracted from the observations that I have already offered on the need to strike a fair balance between promoting at the same time international economic cooperation and sustainable development together with social justice. In agriculture, legal localism cannot be disregarded nor wiped out. But unless legal localism is somewhat counterbalanced by a minimal and non-binding uniform legal framework elaborated under the auspices of independent international organizations, it will be impossible to channel international investments on equitable terms towards agriculture in countries that badly need such investments. Conclusively on this point, UNIDROIT believes that even if agriculture has long been considered an inappropriate field for proposing and developing projects of legal uniformity or harmonization, the time has now come to turn the page and to open a new chapter of its institutional mission by including agriculture in a prominent position among the areas targeted as deserving efforts of private law harmonization. Third and last point, why not only projects reflecting a common core of the law exist in most countries, but also more daring projects seeking to promote better solutions through innovative rules? The reason is less obvious than it might seem at first sight and deserves to be spelled out. New institutional economics is increasingly attentive to the impact of the legal and regulatory framework on economic activity. Modern economic theory associates economic development with the quality of social institutions. Outdated laws and inadequate mechanisms for the enforcement of legal rights are now recognized as generating economic inefficiency and hindering sustainable economic development. This is a particularly serious problem in many developing countries, but it is also a non-negligible problem in a number of developed countries with mature economies. Removing differentials by promoting the adoption of uniform rules reflecting a common core of existing national laws may not be sufficient or satisfactory, in that it may simply amount to a missed opportunity, particularly whenever the adoption of a strongly innovative legal solution may per se produce tangible and easily measurable economic benefits. It would suffice to mention in this respect the extraordinary success that, thanks to the pivotal role of some fresh ideas and an innovative structure, has been achieved in less than 10 years from its entry into force by the UNIDROIT Convention on Cape Town on international interest in mobile equipment, together with its aircraft protocol. Results tell of over 65 contracting states, of which 57 adhering to the aircraft protocol, and a realistic forecast of savings directly resulting from the risk reduction brought about by the mere adoption of the Convention and the Protocol, reaching the staggering amount of $160 billion during the period 2009-2030. Based on this awareness, an intergovernmental agency such as UNIDROIT has come to the firm conclusion that its institutional mission must now increasingly also encompass the duty of proposing new ideas and new solutions, as opposed to simply remaining faithful to the old model of uniformity based on broadly accepted common core rules. This should not be seen by the states, nor by public opinion, as an unauthorized step by UNIDROIT, contravening its mission of promoter of international legal uniformity. In the first place, UNIDROIT, as the other sister agencies, UNCITRAL and the Hague Conference, is a public institution whose lack of financial or political involvement, together with its balanced composition, constitute per se a significant guarantee of independence, neutrality, and non-subservience to any vested special interest. Moreover, UNIDROIT is of course fully aware and mindful of the political boundaries it must respect. Making ultimate policy choices is not within its competence. However, suggesting them, or a panoply of them, as recommended solutions to its member states and to the international community in general is within its competence, although this may have become more evident in recent years than it was in the past. On the whole, good rules, whether innovative or reflecting the wisdom of tested practices, are always capable of inducing progress, based on their own intrinsic good quality. This is the final argument that justifies UNIDROIT's present vision of its role, a balanced but not conservative approach vis-à-vis the challenges posed by the open issue that we are here convened to discuss, namely the issue of which role should be assigned to private law in the context of the international debate on the promotion of the rule of law. Thank you for your attention.
Надо включить микрофон.
All right. One view on the mission of law in an era of change will be presented by Wolfgang Brandstetter, the Federal Minister of Justice of the Republic of Austria. Austria is a state that has a very rich legal tradition. Austrian civil legislation has become a model for many countries as they develop their own legal systems. Today, Austrian lawyers are actively participating in the development of the international legal system. We know that Vienna is the seat of a number of authoritative international organizations, including those that are working towards unification and harmonization of law. Mr. Minister, please, the floor is yours.
Mr. Prime Minister, my dear colleagues, ladies and gentlemen, I am very pleased about this opportunity I got through the kind invitation of my colleague Alexander Konovalov from the Russian Federation, whom I recently met in Vienna, where we had a very fruitful and productive work session. And it is a great honor and pleasure for me to express some thoughts on the issues of this conference and its topic, Mission of Law in an Era of Change. Let me start by mentioning that the general political situation does not really give us reason for optimism at all. The crisis in the Middle East as the root of an incredibly evil terrorist movement which has triggered a wave of refugees and made the Mediterranean Sea a grave for countless desperate human beings. And, of course, the problems in Europe's relations with the Russian Federation, which reminds us of that what happened on our continent in the recent past and which was deemed to have been overcome. The memories which have characterized the month of May should show us the right way forward again. The end of the war 70 years ago should remind us of the truly Herculean efforts of the Soviet Republic, which liberated Austria from a brutal and criminal regime by paying a high price. Almost 40,000 soldiers of the Soviet army were killed during the fights in and around Vienna. And on the 15th of May this year, we in Austria remembered the conclusion of the State Treaty in 1955, It was a sign of hope in times of Cold War, which re-established Austria as a free and democratic state. And this treaty has been the foundation for the present freedom and economic development of our country. So let me use this opportunity to express my very personal gratitude to the representatives of the Russian people who enabled this treaty and secured a peaceful and beneficial future for Austria. This is of special importance for me personally, since I am a son of a man who was active in the resistance movement against the Nazi regime. This Austrian state treaty is based on the fact that Austria was obliged to respect human rights and to guarantee the rights of the Slovenian and Croatian minorities. And that's what we did. And after all, the Republic of Austria not only committed herself to respect such human rights, but this commitment has also become part of Austrian constitutional law by incorporating the entire Human Rights Convention of the Council of Europe in our constitution. And this happened in 1964, not by chance, only 9 years after we got back our freedom and independence again. And this commitment, our European commitment to honor these rights, and thus also protect individual rights and freedoms of all citizens, should point and pave the way to the future as a key to resolving present problems and disputes. And for this reason, Austria attaches such great importance to the respect of human rights and fundamental freedoms, but not with a raised forefinger, rather with the humility of failure. No, we have to try again and again that we improve our systems. And we in Austria, we're also faced with major problems, such as in our penal system, which sometimes does not meet the standards of the European Convention, so we have to work on it. It's not so easy to meet the standards of our convention in daily work, but it's necessary, and we have to try it again and again, even if it's hard and needs strong efforts. But it is, as a well-known Russian proverb says, as you know, bez muki niet nauki. So we have to go on. And the era of change is characterized through new facts and developments which are really bad, to say it very clearly. And unfortunately, we have to encourage all participating countries, in particular those with internal conflicts, to take effective measures to protect minorities and to actively combat the increasing incidences of hate crime. Hate crime, a new phenomenon. Everyone who sows hatred and intolerance against minorities or religious groups has left the framework of the law, therefore becomes an outlaw. But nevertheless, he must be prosecuted by applying criminal law proportionately and effectively. And none among us may claim having no deficiencies in his own national system. And by looking upon current events in the Middle East, we perceive atrocities and brutalities of unimaginable proportions. Apart from the flow of refugees, including women, children, and men narrowly escaping genocide, we must also recognize the dark side of modern communication technology, as already mentioned, namely the internet and the so-called social media, which terrorists can misuse for propaganda purposes. But such misuse not only generates disgust, but also brings about poisoned fruits by misleading young people, full of idealism, solidarity, and initiatives to actively participate in combat operations, or at least to glorify and justify alleged heroic deeds in hate postings. From my point of view, this constitutes a repulsive betrayal and misuse of parts of our younger generation. So we shouldn't be indifferent, but do what we can against this huge new problem together. I know that quick and simple solutions are not in sight. Criminal law is a blunt weapon when it comes to avoiding and combating misguiding convictions. But in our democratic society, we must indeed also show strength in defending our common values and punish any violence motivated by racism or intolerance. In the light of such developments of hate crime, I have announced a tightening and sharpening of our criminal law referring to the offense of hate speech, because manifestations of hate speech and hate crimes must not be tolerated. Such manifestations which constitute a perversion of the right of freedom of opinion, also according to the case law of the European Court of Human Rights, have to be fought by criminal law too. Ladies and gentlemen, let me come back to the era of change and to the role the law plays in shaping international relations. Considering the relations between the Russian Federation and Europe, or rather the European Union, since Russia is a part of Europe, I would like to quote your famous Russian author, Dostoevsky. So, by the way, thanks to my colleague for this guided tour this morning, which gave me the chance to follow the tracks and traces of this great author. And Dostoevsky wrote so many strong sentences. And I just want to quote one of his strongest sentences. It's a sentence: "The feelings of those we love most are most easily hurt." Ladies and gentlemen, the common European house we talked about in the era of Gorbachev and later on was constructed bigger than it is now. It was based on the European Convention of Human Rights as a strong fundament, and its roof should cover Russia and its citizens too. No question of it. And by the way, if there are any problems with the house rules, they should be clarified inside and not outside of the house. Just now there's a lack of mutual respect, and for this reason it would be worthwhile from my point of view to re-evaluate the potential of the Council of Europe. First of all, Russia is a full member of this forum and has accepted specific obligations in matters of fundamental rights. Secondly, all other members can discuss with Russia in the Council of Europe on an equal basis. This willingness to hold a dialogue among equal members should be kept and expanded further, and we in Austria acknowledge with appreciation that judgments of the European Court of Human Rights have an important effect on legislation and jurisdiction. In the same way as in Austria, where we were obliged in many areas to amend acts of legislation, modifications of the criminal code and the code of criminal procedure in Russia have also resulted in reducing the total number of pre-trial detainees and in improving detention conditions, according to the Convention. Unrestricted appreciation is due for that. It is also quite significant that the Russian Constitutional Court and also other courts of that country in their own judgments have made references to case law of the European Convention of Human Rights. We have to enforce this legal dialogue without any restrictions, barriers, or walls. Therefore, I would consider it an important step to cancel the suspension of voting rights for Russian representatives in the Parliamentary Assembly of the Council of Europe, as soon as possible. Evidence that such a dialogue can be very fruitful is provided by the introduction of the proceedings in Russia in 2012-2013 along the lines of European legal practices. This introduction was accompanied by the Council of Europe in the form of a training project for judges and legal administrative staff with the participation of experts from the Netherlands and, of course, from Austria. The conclusion of Austria's experiences is evident. A willingness to hold a dialogue and keep it does not mean appeasement if such dialogue is held on the basis of firm legal convictions. With this in mind, I wish that a fruitful exchange of ideas on the rule of law in international relations should take place in this forum, and I'm sure it will. Ladies and gentlemen, at the end of my speech, let me add some short personal remarks. Last Saturday, I was attending the European Song Contest in Vienna, together with more than 10,000 enthusiastic people in Vienna's big city hall, and I was happy about the huge success Russia had. The Russian singer Polina Gagarina had a great performance, indeed, and she was second at last among 40 countries joining the European Song Contest, a great success, and she deserved it for the wonderful song, A Million Voices. So, Russia was on the top of the countries that are all doing their very best to succeed in this prestigious European contest, which was watched by almost 300 million people on TV. So since the next shape of my papers is on the bottom, I have to fetch it. So this, ladies and gentlemen, was a huge success for Russia and at the same time a great success for Europe. It was a great success for Europe to have Russia as a participant. And this contest in Vienna, and this is quite a symbol, would have been much less attractive without Russia. And this event was entitled Building Bridges from the Beginning. And that's what it really did. Well, we Austrians, we are predestinated for building bridges because of our geography and our history. As mentioned, we got our freedom and independence again because of the bridges that had been built in 1955 between Washington, London, Paris, and Moscow. So we got back our freedom and national identity by the international community at that time, and that's why we Austrians want to give something back to it. And for this reason, we are eagerly participating in all activities, bilateral or on an EU basis, that help other countries to strengthen and improve their legal system and their rule of law standards. We did this especially in Eastern Europe and the Balkan area, and activities like that, they are so important for two reasons. First, a strong and reliable legal system is the necessary basis for investments, prosperity, and a flourishing economy, as Mr. Prime Minister already pointed out. But we must not forget reason number two. If you can guarantee each and every citizen that his fundamental rights are efficiently protected by law, especially referring to ethnic minorities, then this leads you to the point where the national or geographical borders are becoming less important. And we Austrians, we have a good best practice example, thanks to Italy and the United Nations. And this example could work in other regions of Europe too. It's the status of South Tyrol, where our South Tyroleans in Italy can make use of the language and the guaranteed rights without any problems. And last year, there were plans to change the structure of the court system in South Tyrol. Our Tyroleans would have suffered from this plan because they would have lost an important regional court. When this problem was raised, it did not take long until my colleague, Andrea Orlando, promised me that these plans would not become reality. Thanks to Andrea, who is with us today, thanks to Italy, and by the way, congratulations for Italy too. They ranked third in the song contest, only beaten by Sweden and Russia, of course. But what we, Italy and Austria, have reached together in South Tyrol, this, ladies and gentlemen, this is Europe at its best. And I would strongly like Russia to be a part, or at least a strong partner of it. Ladies and gentlemen, let me come to the end. The last century could be called the century of walls. So let's make this century the century of bridges. It's not only a wish, it's not only a Sunday speech, no. It's nothing less than our responsibility. So let's face it. Spasiba.
Спасибо огромное, господин.
Thank you very much for your speech, Mr. Brandstetter. We've just heard from the representatives of the countries of the Continental Law, and on this note I would like to introduce the guest of honor of our forum, one of the outstanding representatives of the academic community of the State of the Common Law, the Professor Emeritus of Oxford University, Mr. John Finnis. Mr. Finnis started teaching the law back in 1966. Since then, the range of his academic interests has included theory of law and politics, the ethics and moral foundation of law, and constitutional law as well. In his monographs, Professor Finnis writes about the ethical grounding for the norms of the positive law, in particular the correlation of human rights and the common good, and he develops on what was formulated by Jean-Jacques Rousseau, John Locke, and other researchers of the Enlightenment period. He mainly focuses on the building up on the legal theory as combined with the theories of the 23rd century.
Moderator, Prime Minister, Minister, councillors and other ministers, and ladies and gentlemen, it's a privilege to be able to address so many of you involved, as you mostly are, in the practice and application of law, and a privilege to be able to do so on a platform with distinguished persons intimately involved in the deliberations and decisions which result in the making of new laws and reformation of old laws. Though I have had some small involvement in both these important responsibilities, my principal vocation has been the teaching, investigation, and critical discussion of the reasons why every political community needs laws, and what kinds of laws it needs to regulate the authoritative decisions, legislative, judicial, administrative, without which its people could not flourish in the diverse ways in which they are morally entitled to be helped to flourish, to do well in undertaking, coordinating, and carrying out the moral responsibilities and opportunities of private life in their families, their enterprises, their civil associations of every kind. So it's a special privilege to be invited to share with these distinguished officials and with you all a few academic reflections on this great practical question of the role of law in an era of global change. That role will be an instance, or at most a development, of the role that law has always performed, whenever its value as a means to good ends has been sufficiently acknowledged and respected among those to whom it is addressed. And, as I just remarked, those to whom our country's law is addressed include us all, whether as citizens or as, for a time, officials of the government of our country. So we can ask, in what ways does law serve as a means to good ends, ends that cannot be achieved well without the help of law? As we all know, every law is a more or less general proposition, a unit of meaning expressed and conveyed by the sentences, the statements in the published text which declares that law to its subjects, including those whose office will be to apply it administratively or judicially. The work of the lawyer, whether as a student, a teacher, a practitioner, or a judge, begins with the effort to find, by our craft's techniques of understanding and interpretation, to find what truly are the propositions of law that truly are the valid laws that are conveyed by those statements in those texts, when they are related to all the other relevant textual statements and resultant established propositions of our law as a whole system. This, in its way, is a search for truth, not some grand universal truth, but truth nonetheless. Truth about what our lawmakers have committed us to and have taken responsibility for committing us to comply with, insofar as it is applicable to the particular situations of our individual and associative life. So there is honesty and dishonesty, as well as competence and incompetence in interpretation and application. I have tried to help my students to understand and appreciate how far the possibility of justice according to law, or of doing injustice under form of law, depends on their personal honesty as legal practitioners. For as practitioners, they will have the opportunity of losing, concealing, or secretly destroying the documents on which their opponents in litigation and the court or arbitral tribunal may or will rely in pursuing and delivering the judgment in which the law, correctly interpreted, is applied to the historical facts established as real facts by true evidence distinguished from false claims. An absolutely primary role for law, a reason for having laws, is to enable disputes to be ended and justice between persons re-established on the basis not of one party's superior force or cunning or ability to purchase judgment, but instead on the basis of valid laws in force at the time of the dispute's causa and applied accurately to the real, true, not feigned or imagined facts. So, besides the dramatic and searing appeal to truth that on occasion might be directed against legal forms and power, by reminders that, as was famously said, a simple act of an ordinary courageous man is not to support lies. Let them, lies, come into the world and even reign over it, but not through me. One word of truth outweighs the whole world. Besides such appeals, there is the more ordinary and prosaic day-by-day fidelity to truth demanded of all law's practitioners, judges, and arbitrators. Without that fidelity, law can scarcely fulfill its role in this era or in any era. Now, as we know, one and the same proposition of any kind can be expressed in many different statements or sentences. For example, statements or sentences in Russian or English or German or Italian, the same proposition. Thus, we can understand and share or discuss each other's intentions and objections and ends and chosen means. Through these propositions about what is to be done or not to be done, or about what there is power, faculty, or authority to do and create and effect, through these a commonality or community of understandings and plans can come into being. And the distinctiveness of law is that these plans link the past with the present and the future. The work of, for example, the engineer or soldier is to relate the present to the future effectively. But the work of law is to relate our present and near future to the commitments made in and for our community in the past by acts of constitution-making, legislation, adjudication, or award, or other official decision affecting someone's legal status or rights or obligations. The commonality is not simply among contemporaries living together or communicating with each other in the present. It is a commonality between us now and those who went before us and who established the statutes, customs, institutions, contracts, and trusts or usufructs that retain their validity despite their age and because of their lawful origins in the past. By respecting and honoring them, we make it also possible and rational to legislate now, or to make contracts or treaties now, in the faith that in that future in which today's present will be past, our lawmaking decrees and acts will retain their relevance as valid and applicable then in the future because validly made now. The reality of change, indeed global change, does not nullify or undermine these fundamental truths about law. That law links present and future to the past, not by magic or superstition, but by rational design and reasonable fidelity to undertakings and commitments. Design and fidelity that can yield rich fruits in stability, predictability, respect for legitimate expectations, and consequently in investment, complex sequential exchange, and other sources of enhanced productivity and thus enhanced human flourishing. And among those good fruits is the dignity and rightful liberty of the subjects who know that their compliance with law will be met reciprocally by courts and other officials of every kind in a mutuality of expectations and obligations which ensures that their status as free subjects of the law is not a form of subjection or enslavement, crude or subtle. This stability of the rule of law is not immobility. It in no way excludes lawful amendments of past enactments. In order to accommodate changing needs and changing conditions for human flourishing, and to do so without a retroactivity that would defeat the legitimate expectations of the law's subjects. For past, present, and future are abstract names for flesh and blood people, for those of our people who made the commitments embodied in laws and lawful institutions for the benefit not only of themselves and their neighbour, but also and even equally of us, their successors, who should and do have the same concern for our children and other successors. The obligation of law is not owed to the lawmakers as rulers. It is owed by me, for example, to all who my fellow subjects to all who are my fellow subjects of the same law or of the same system of law, our law. The authority of our lawmakers as rulers is above all a responsibility of serving the common good of our community, in which each member is entitled to be considered and respected. That common good is itself to be understood as in truth an ensemble, a set, a collection of common goods, that is, of communities, familial, local, educational, professional, agricultural, industrial, commercial and financial, each with a common good that serves the flourishing of each of the persons who are its members, in accordance with their particular needs, their particular contributions and aptitudes, and the protection of the whole. The branches of law we call private law enable and facilitate a flexible, far-reaching system or network for coordinating these diverse common goods. A system that is truly a coordination, not a directive management on the model of a military formation or sporting team or other technical unitary goal, win or lose operation or formation. To confer on some of us the responsibility and authority of leadership, or even to acknowledge that authority when it emerges without lawful conferral, is to accept a substantial and permanent risk of abuse. Abuse that, if it occurs, is likely to be severe, because political authority and state law must bear the responsibility of exercising physical force against persons and their possessions for the sake of preserving justice, and that capacity can always de facto be diverted to unjust and unlawful purposes. Against such diversion, we erect the legal obstacles of constitutional separation of powers, judicial process, the remedies of public law, and so forth. But in the end, our security against the standing possibilities of abuse of law or of raw governmental power depends upon the willingness of those in authority to accept that they are members, children of one community of solidarity, and, under providence, of one destiny and one shared memory, one patriarch, and therefore to accept the reciprocity of subjection to the same equitable laws themselves, to which their fellow citizens are subject. For as far forward as we can envisage, I believe, the global community of humankind as a whole will not yet be a community of such solidarity, in which these intimations of reciprocity and commonality would be sufficiently strong, sufficiently reliable and focused for it to be reasonable to entrust to some individuals the responsibility, authority, and power of lawmaking and law enforcement. Our responsibilities to our fellow members of the global community of mankind will be better served, therefore, by fidelity to promises, to treaties, and other international or transnational agreements, and by forms of cooperation broadly similar to the model of international arbitral institutions and processes. Those are and will be genuine moral obligations, subserved by coordination of national legal forms and processes. but they are not yet law in its central form and role, though they reasonably are called international law to signify the judicially arbitrarily enforced obligatoriness of those rules and their adaptability or reformability by agreement. Thank you.
Well, thank you very much, Professor Finnis. Indeed, in the past year, in our planet, both in the humanitarian, political and economic areas, we have seen events and developments that would have an impact on the stability of world order. But I think that law has been traditionally one of the most efficient, reasonable and morally justified instruments of conflict resolution in this rapidly changing world. Today, discussing the subject matter of this plenary session, we would involuntarily refer to the experience of the lawyers who have been working after World War II, when the United Nations was established and a new system of international relations based on the rule of law was established. Today, in the second decade of the 21st century, we can be certain in saying that the mechanisms developed back then have not lost their significance, and the UN system has remained a pivotal corner of the international security. And in this regard, we are particularly interested in the speech by the Undersecretary for Legal Affairs of the United Nations, Mr. Miguel de Soares, whom we would have the honor to welcome here at the plenary session. Please, the floor is yours.
Your Excellency, Prime Minister Medvedev, Your Excellency, Mr. Konovalov, distinguished participants of the 5th St. Petersburg International Legal Forum, ladies and gentlemen. Добрый день. Спасибо за приглашение принять участие.
Thank you for the invitation to participate in this important legal forum.
I am truly honored to address this large and diverse gathering of governmental and international affairs officials, judges, lawyers, legal practitioners from many regions of the world. And I would like to commend the organizers for their choice of the topic for this year's plenary discussion, the mission of law in an era of change. And this truly resonates with the current international climate and the constantly changing nature of today's international relationships. In the modern world, nobody is immune from the challenges of local and regional conflicts, post-conflict peace building, economic crisis, infectious diseases, climate change, just to name a few. In the case of such challenges, the law is the only common ground and framework that is available to those who must seek to address them. Mr. Prime Minister, ladies and gentlemen, in preparation for this forum, I am sure that many of my fellow speakers were looking for inspiration in the enormous richness of Russian literature and legal doctrine. But perhaps the oldest known Russian codified legal source, dating from around the 10th to 12th centuries, Russkaya Pravda, would be a better place to look. The etymology of the Russian word pravo, law, goes back to this source. It grows from the word pravda, which means truth in the modern Russian language. And I believe that this understanding of law as the truth, and with that as both standard and ideal, very much reflects the mission of law in the modern world of change. As the Legal Counsel of the United Nations, I inevitably approach the mission of law from an international perspective, in particular from that of the United Nations. I'm often challenged with questions about the role and mission of the United Nations and of its foundational document, the Charter. Do the institutions and mechanisms of the United Nations operate to the benefit of all of its member states? Does the organization have the capabilities and working legal instruments to address the complex challenges and threats which are increasingly abundant? Can international law truly be considered as a guarantor of stability in a rapidly changing world? And is the Charter of the United Nations, which was signed 70 years ago this month, still up to the task of ensuring peace and security? These are all difficult and pertinent questions which are rooted in the spreading conflicts in different regions of the world and the new or re-emerging challenges such as pandemic diseases, piracy, terrorism, transnational organized crime, and mass migration. Certainly, the 70 years since the creation of the United Nations have been difficult, and that's for sure. And I would have to admit that in certain instances, it has failed to prevent emerging conflicts or adequately respond to ongoing ones. However, there is a common understanding that without the United Nations and the laws and legal mechanisms that it has put in place, the world would have been a much more chaotic and dangerous place. The organization, which was created in the aftermath of the Second World War, was entrusted by its founding fathers with the task, first and foremost, of preventing a future tragedy on the same scale. And as we all know, in this mission, the United Nations has succeeded. This task, and I quote, to save succeeding generations from the scourge of war, is still at the heart of the raison d'etre of the United Nations. It is reflected in the global attention to the 70th anniversary of the end of the Second World War and the recent participation of the United Nations Secretary General in the anniversary events of the 9th of May in Moscow. In the words of the Secretary General, at the ceremony for the planting of the Tree of Peace and Unity to commemorate the end of the Second World War and the establishment of the United Nations, held at the United Nations headquarters in New York, and I quote, "In establishing the United Nations 70 years ago, the founders planted the seeds of an organization they hoped would lead the human family out of horror and into a better future." Now, 70 years have passed and the United Nations has grown into the only truly universal international organization, providing its member states with a safe, common place where every nation can speak and be heard in order to prevent or resolve conflicts and diffuse potentially dangerous situations. It is a unique forum designed to harmonize the decision-making of states and solve their differences by peaceful means. Its legal basis, the Charter of the United Nations, remains foundational to the international legal system. Its core principles, set out in Article 2, including the equality of sovereign states, the non-use of force or threat of the use of force, and the peaceful settlement of international disputes, are the framework within which international relations are conducted. This distinct durability owes itself to the fact that the Charter is a living instrument which has been able to successfully adapt to emerging challenges and threats. A perfect example is peacekeeping, which nowadays forms an essential part of the organization's work and the lion's share of its budget. Now, for the year from July 2014 to June 2015, the peacekeeping budget will be 8.5 billion, a number which I believe it speaks for itself in a time of economic difficulties. However, what now represents one of the organization's most vital activities is not even mentioned in the charter as such. It was introduced later on by the General Assembly and the Security Council in an effort to tune the organization to the realities of a changing world. Now, this example further demonstrates that in order to find legal solutions to addressing new challenges and threats, it is important that the international community stands as one. The unity among the members of the Security Council, especially its 5 permanent members, is of the utmost importance in this regard. The united approach of the members of the family of the nations has enabled us to successfully counter piracy off the coast of Somalia, to respond to the Ebola pandemic in Africa, and to bring stability to conflict-torn countries like Sierra Leone and Liberia. I am fully convinced that the political will, commitment, and unity among member states will make it possible to find appropriate legal solutions to other complex problems of the modern world. This idea of the unity of all players in the international arena, big and small, will no doubt be reflected in the discussion track on supranationalism and sovereignty in contemporary international relations, which I'm planning to attend in the coming working days of the forum. Now, when I was preparing for this forum, I came across a very instructive statement by the second Secretary General of the United Nations, Dag Hammarskjöld, entitled "The Nation and the World." Back in 1955, he confronted this difficult question of how to find a balance between the nation and the world, the individual state, and the multilateral international structures. He said, and I quote, "Everybody today with part of his being belongs to one country with its specific traditions and problems, while with another part he has become a citizen of a world which no longer permits national isolation." Seen in this light, there could not be any conflict between nationalism and internationalism, between the nation and the world. End of quote. The mission of law at the international level is to help the individual nation to better integrate in the world, on the basis of the fundamental principle parin parum imperium non habet, an equal has no power over an equal. Ladies and gentlemen, this idea that nations and sovereign states do not exist in a vacuum but cooperate on the basis of law brings me to another dimension of the mission of law in the current international setting, the rule of law. For building a safer, more secure and united world, the task of promoting the rule of law at the international and national levels is of particular importance. Responsibility for ensuring the rule of law at the national level naturally rests first and foremost with the respective nation states. At the international level, the corresponding efforts of the United Nations include encouraging the progressive development of international law and its codification, supporting the growing network of international treaties, establishing and promoting international mechanisms open to the states for the peaceful resolution of their disputes, establishing or helping to establish international and hybrid criminal courts and tribunals to prosecute those responsible for international crimes, and training and education in international law. The Office of Legal Affairs of the United Nations, which I have the privilege to head, is in the lead on many of these activities. The rule of law features high on the Secretary General's agenda. In these, he is following the lead that was set by member states at the milestone 2005 World Summit. In the World Summit outcome document, the heads of state and government affirmed that human rights, the rule of law, and democracy, and I quote, are interlinked and mutually reinforcing and that they belong to the universal and indivisible core values and principles of the United Nations, end of quote. And again, they have reaffirmed their, and I quote, commitment to the purposes and principles of the Charter and international law and to an international order based on the rule of law and international law, which is essential for peaceful coexistence and cooperation among states, end of quote. Mr. Prime Minister, ladies and gentlemen, the topic of the mission of law in an era of change is vast and multidimensional, and I have had the chance to barely touch upon only the tip of the iceberg. I would like to praise the organizers of this forum who have challenged the participants with difficult questions and have managed to shape a wonderful program. I anticipate a fruitful exchange of opinions with my learned colleagues in search for a common ground. And of course, we all will be inspired by the glorious history of our host city. During the Second World War, this city faced unspeakable tragedy and survived the most horrendous and prolonged siege. Its population stoically held out through 872 days without food, fuel, and basic living supplies until that siege was broken. Now let the example of heroism, compassion, and resilience of these common people should be a source of inspiration to us and a reminder that even the most complex and daunting of challenges surrender in the face of unity and true commitment. Большое спасибо.
Большое спасибо.
Thank you very much, Mr. Serpa Soares, for your intervention. I would like to thank once again all the panelists for their interesting presentations. And I would like to ask Prime Minister Medvedev to sum up the outcomes of our discussion.
Thank you, Mr. Yakovlev. I studied the reports very thoroughly, and I was going to try and tell you my thoughts about these reports, but I looked outside and this beautiful weather, and after the reference to the presentation of our beautiful Polina Gagarina, and bearing in mind that we are expecting a concert this evening, we should remember that our performers can not only sing in Eurovision, but they have other feats that they can show. So I think all the participants in this forum, we remember that these events may be lengthy, but the presentations of our colleagues referred to the main issue of our discussion, the mission of the law in this world. Despite different differences in our approaches in a legal system, we still have the same view on the main issue that unites us. We serve the law. We believe that only law may settle conflicts, may resolve conflicts, and we are sure that the law has great potential. I wish you all great stay in St. Petersburg and participation in the forum. Thank you.
The plenary session is closed now, dear ladies and gentlemen. Today at 8 p.m. we would like to invite you to the concerts by Denis Matsuev and his colleague at the Philharmonic Society, and the reception devoted to the opening of the 5th International St. Petersburg Legal Forum.